I'm going to call the House Judiciary Committee to order. Madam Clerk, will you please call for attendance?
Chair Lightner.
Here.
Representatives Bagol.
Here.
Wozniak.
Here.
Harris.
Here.
DeBoyer.
Here.
Johnson. Here. Schutte.
Here.
Carter.
Here.
Pope. Here. Breen. Scott. Present. Madam Chair, you have 10 members present. You do have a quorum.
Thank you, Madam Clerk. Rep. Wozniak moves to excuse absent members. Hearing no objection, absent members are excused. The next order is Rep. Harris moves to approve the minutes of the prior meeting. Hearing no objection, the minutes are approved. Next, we're going to move on to adopting Rep. Wozniak's sub for House Bill 4524. Rep. Woz, would you like to reference it or speak to that before we continue to vote?
Yeah, we have an H1 on that, and all it does is clarify that there's certain amenities that are excluded from the change, particularly under drain codes or governmental or quasi-governmental bodies like drainage districts and energy utility facilities. So in essence, after 40 years, if there had been a recorded easement or anything else on a particular property describing an interest in that property, it would expire. And the reason for that is many developers coming into property would get surprised by certain instances where it's greater than 40 years with the interest on the property. So subject to easements of record is no longer sufficient. I won't go further.
Thank you, Rep. Woz. With that, we'll have that you move to a.
That's the H1.
Okay. I'm going to have you move to adopt the substitute for 4524. Madam Clerk, will you please call the roll?
Chair Lightner.
Yes.
Representatives Bagol.
Yes.
Wozniak.
Yes.
Harris.
Yes.
DeBoyer.
Yes.
Johnson.
Yes.
Schutte.
Yes.
Carter.
Yes.
Pope. Yes. Breen. Scott.
Yes.
Madam Chair, you have 10 yeas, 0 nays, 0 pass. The motion prevails.
Okay, before we move on to reporting House Bill 4524 as substituted, we're going to read in some cards. We have David Pearson, Real Property Law Section, supports the bill, does not wish to speak. Sean Cecil from Michigan Realtors supports the bill, does not wish to speak. And Don Crandall from Home Builders Association supports the bill, does not wish to speak. With that, we'll have Rep. Bagol move to report House Bill 4524 as substituted. Madam Clerk, will you please call the roll?
Chair Lightner.
Yes.
Representatives Bagol.
Yes.
Wozniak.
Yes.
Harris.
Yes.
DeBoyer.
Yes.
Johnson.
Yes.
Schutte.
Yes.
Carter.
Yes.
Pope.
Yes.
Breen. Scott.
Yes.
Madam Chair, you have 10 yeas, 0 nays, and 0 pass. The motion prevails.
Thank you, Madam Clerk. Next, we're going to move on to House Bill 4506. It looks like we have 2 amendments being offered by Rep. Hope. Okay. So we're going to start with the First Amendment. Rep. Hope, would you like to speak to your amendments? Amendment, the first one.
Yes, ma'am, thank you. And which one are we considering the first one? Okay, gotcha. Mine don't have numbers on them. Yeah, both these amendments, apply to the same, bill, and what this one would do is limit the application of the consecutive sentencing, currently called for to just those juveniles or 19 and 20-year-olds who have committed more than one first-degree murder, which I think is in line with the stated intent of the bill.
Madam Clerk, would you please call the roll? Oh, yeah, you need to move it. Are you moving your amendment?
I'm moving my amendment.
Pope
Amendment
Amendment number 1 that starts with amend page 4, line 9 after B. Chair Lightner.
No.
Representatives Bagol.
No.
Wozniak.
No.
Harris.
No.
DeBoyer.
No.
Johnson.
No.
Shooty.
No.
Carter.
Yes.
Hope.
Yes.
Breen.
Yes.
Scott.
Yes.
Madam Chair, you have 4 yeas, 7 nays, 0 pass. The amendment is not adopted.
Thank you, Madam Clerk. Rep. Hope, would you like to speak to amendment number 2, that as well for 4506?
Very
And move it.
briefly, yeah, just by way of explanation, I move this amendment, and what it does is it puts the minimum and maximum sentences available in line with that which is currently in place for 17 and 18-year-olds.
Madam Clerk, she moved her amendment. Would you please call the roll?
Chair Lightner.
No.
Representatives Bagol.
No.
Wozniak.
No.
Harris.
No.
DeBoyer.
No.
Johnson.
No.
Shooty.
No.
Carter.
Yes.
Pope.
Yes.
Breen.
Yes.
Scott.
Yes.
Madam Chair, you have 4 yeas, 7 nays, 0 pass. The amendment is not adopted.
Thank you, Madam Clerk. I'm going to read in a card. This is from Nicole Porter. The Sentencing Project opposes the bills 4506, 07, and 4508 and does not wish to speak. Paula Bowman of League of Women Voters does not support the bills 4506, 4507, 4508, and does not wish to speak. With that, I will move House Bill 4506 with recommendation. Will you please call the roll?
Chair Lightner.
Yes.
Representatives Bagol.
Yes.
Wozniak.
Yes.
Harris.
Yes.
DeBoyer.
Yes.
Johnson.
Yes.
Shooty.
Yes.
Carter.
No.
Pope.
No.
Breen.
No.
Scott.
No.
Madam Chair, you have 7 yeas, 4 nays, 0 pass. House Bill 4506 is reported with recommendation.
Thank you. And now we're going to move to House Bill 4507. Rep. Bagol moves House Bill 4507 with recommendation. Madam Clerk, please call the roll.
Chair Lightner.
Yes.
Representatives Bagol.
Yes.
Wozniak.
Yes.
Harris.
Yes.
DeBoyer.
Yes.
Johnson.
Yes.
Shooty.
Yes.
Carter.
No.
Pope.
No.
Breen.
No.
Scott.
No.
Madam Chair, you have 7 yeas, 4 nays, 0 pass. House Bill 4507 is reported with recommendation.
Thank you, Madam Clerk. Now, House Bill 4508. Rep. Harris moves with recommendation House Bill 4508 to the floor. Madam Clerk, please call the roll.
Chair Lightner.
Yes.
Representatives Bagol.
Yes.
Wozniak.
Yes.
Harris.
Yes.
DeBoyer.
Yes.
Johnson.
Yes.
Shooty.
Yes.
Carter.
No.
Pope.
No.
Green.
No.
Scott.
No.
Madam Chair, you have 7 yeas, 4 nays, 0 pass. House Bill 4508 is reported with recommendation.
Thank you, Madam Clerk. Next, we're going to have a quick presentation on House Bill 4668. I have a couple of cards here. I have Daniel Croft of Center for AI Risk Management and Andrew Doris of Secure AI Project, both wishing to speak to the bill. You gentlemen can come on up here and just click the red button. And either one. Just make sure when you speak, you click the red button there. And this is on House Bill 4668. It's a AI policy, and these gentlemen are going to speak to that. Thank you. You have the floor.
Wonderful. Thank you, Chair Lightner, and to all of the rest of you for the opportunity to testify today. My name is Andrew Doris. I'm with the Secure AI Project, which is a small nonprofit that develops and advocates for pragmatic policies to reduce the risks of severe harm from advanced AI. One of those policies is House Bill 4668, which we've worked closely with Chair Lightner and her staff to develop these past few weeks. And to explain explain what the bill does and why it's important, I think it might be helpful if I first take a step back to talk about the problem that it's trying to solve, which is tied to the fact that AI is moving very quickly. As you all are aware, you may remember back when ChatGPT first came out in 2022, it caused a big stir. But back then, it still could not reliably count to 10. It could not multiply two-digit numbers together consistently. And today, these same models, just 3 years later, are winning math competitions. They can pass the bar exam. They're very good at coding and chess and lots of other areas where they've gone from pretty basic to better than any human in just a few years. And in some ways, that's really exciting, right? We think AI has enormous potential to advance science and education and healthcare. And probably in 10 or 20 years, it's going to have changed the world in ways we can't even foresee. The trouble is that AI is not just becoming generally more capable, but also more capable in a few specific ways that present really major risks to our safety and security. For example, it's becoming really good at hacking, so it could be used to help pull off a major cyber attack. It's able to give instructions for how to create a bioweapon and then how to distribute that to infect a lot of people in a public place. It increasingly behaves in ways that its creators struggle to control. And this is stuff that some of the leading AI experts have warned about for years. Geoffrey Hinton, for example, won the Nobel Prize for his work on machine learning, and then he left Google so that he could speak freely about these risks. And it's also stuff that the leading AI companies have admitted that their models can do. Just this past month, OpenAI had a quote that its latest model was on the cusp of being able to meaningfully help novices create known biological threats. Anthropic had a similar quote that you could try to synthesize something like COVID or a more dangerous version of the flu, and basically our modeling suggests that this might be possible. And this is about models that already exist, right? So we're already in some fairly dangerous territory. And if you look at what the next few years, you look under the hood a bit at what's been driving these major gains in progress, you'll see that it's factors like the amount of computing power that they're using to train the model, or how long the model is able to keep thinking at a time. And over the next few years, those drivers are expected to go up really, really fast based on the size of the investments that these companies are making to make this technology. So even by this time next year, a lot of experts worry that we're going to be in a much scarier place and that the window to get out ahead of that is closing pretty quickly. We think that the way to get out ahead of that is to require the companies building these models to develop what's called safety and security protocols, describing how they will test their models for these dangerous capabilities and what safeguards that they will put in to mitigate those risks. Thankfully, the largest AI companies already do this on a voluntary basis. They've already agreed to do this a few years back. So we know it's something that they can do without too much trouble. But as of now, there's nobody keeping them to those promises. And because it's such a competitive field, we worry about the conditions for a race to the bottom on safety and pressure to cut corners on that. And that's where this bill comes in. Importantly, the bill would only apply to very large companies that spend more than $100 million a year developing these foundational models. So small startups, mid-sized companies, none of those would be affected by this bill at all. And at a high level, it would essentially require these companies to do four things. First, to create, publish, and follow the safety, security, and protocols that meet certain criteria to guard against what we call critical harms. These are harms that cause over 100 casualties or over $1 billion in economic damages. It's not little stuff that they need to prepare for. They don't need to prepare for everything that could possibly go wrong, only these major tragedies. Second, they would provide quarterly reports on how they're implementing that safety and security protocol. For example, what tests they've conducted on their models over the last 90 days and what were the outcomes of those tests. Third, they would have a third-party auditor, an independent auditor, come in and confirm that they're following their own safety and security protocol. They're not imposing uniform rules on everybody. They're just saying whatever you've committed to publish to follow, make sure you're actually following it. And then finally, the bill would establish some whistleblower protections for employees who report to the authorities that one of these models is demonstrating one of these potential critical risks in a way that is not being mitigated by this protocol. All of this is based on some pretty common sense principles of transparency into how these big AI companies are managing these risks, and trust but verify, right? Just to say, these companies say that they're testing for this stuff, but we want to make sure that that's true. So that's a high-level summary of what the bill does, and I'd be happy at this point to either pass over to Daniel or take questions as you guys prefer.
Sure. Well, I would go ahead and do the presentation first, and then we'll do questions. Thank you.
Thank you, Chair Lightner, Vice Chair Begol, Vice Chair Carter, and the committee for making time today to talk about the risks and benefits of artificial intelligence, something that I think is going to be particularly important in the state of Michigan. My name is Daniel Croth, and I'm a senior researcher at the Center for AI Risk Management and Alignment, a non-policy AI policy research center, and a non-resident fellow at the Berkeley Risk and Security Lab at the University of California, Berkeley. I've worked on technology and security issues, particularly those related to artificial intelligence and nuclear weapons, in various roles in think tanks, government research, including the Wilson Center, the Special Competitive Studies Project, and Lawrence Livermore National Laboratory. More importantly, though, I'm a Michigander. I grew up about 20 minutes from here in Okemos. I ran track and field at Michigan State, and I live in Ann Arbor. I'm proud to see our state engaging with the unprecedented benefits and unique challenges AI is sure to bring to Michigan. I'm here today to share my perspective on these challenges and how we can overcome them to get the best of AI while avoiding the worst of it. Getting this right for our state will require an understanding of the unique nature of the risks posed by AI. AI isn't just ChatGPT. It's a family of technologies designed to perform tasks that normally require human thinking, like understanding speech, recognizing images, making decisions, or solving problems. It's this problem solving and autonomy that make AI incredibly promising, and like many powerful tools, potentially dangerous as well. For example, some advanced AI systems already have the capacity to make and execute complex plans. In an independent study, advanced AI models were challenged to beat a chess-specific AI system at chess. Unable to beat the specialized system at the game, several of the advanced models, including the Chinese DeepSeek R1 model and the American OpenAI O3 model, identified and exploited cyber vulnerabilities in the computer hosting the match to hack their opponent, deleting pieces from the game file so that they could win, or in some cases forfeiting the game on behalf of their opponent to achieve victory. Hacking to win at chess is almost funny, but it's much less funny when our healthcare or industrial control systems are on the other side of the board. In view of this, I'd like to make 4 points. The first of these is that advanced AI systems pose new kinds of risks, and that some of those risks could be potentially consequential. The most obvious risks stem from the misuse of powerful AI tools by bad actors. Advanced AI systems with poor safeguards could allow homegrown criminals or foreign adversaries to execute sophisticated cyber attacks at scale, adapting to and circumventing response efforts. Perhaps more consequentially, many of the AI systems intended to identify promising drug candidates in the pharmaceutical industry could also be misused to identify especially dangerous substances, potentially allowing for potent new chemical or biological threats. Other risks come from over-trusting AI systems, deploying them in places where they make mistakes or could cause harm from poorly defined goals. In testing environments, AI systems come up with unexpected solutions to novel problems. That's part of what makes them so valuable. But this asset becomes a liability when an AI system charged with increasing the efficiency of a factory saves on waste management by discharging toxic waste into a nearby river, perhaps without human direction to do so. And risks may also come from highly capable models themselves under certain circumstances. What could happen, for example, if a sophisticated AI model were allowed unfettered access to the internet, perhaps creating a copy of itself to evade safeguards rightly placed on it to prevent it from executing certain instructions? My second point today is that the capabilities of the AI systems that we have now are the tip of the proverbial iceberg, and that AI systems are likely to be far, far more capable in the near future. When we discuss the benefits and risks of advanced artificial intelligence today, we have to account for the incredible pace of progress that we're making on AI research, development, and deployment. 4 years ago, I was amazed that AI could write a coherent children's story. 2 years later, in an informal experiment at Tufts University, I found that graders could not readily distinguish between essays written by AI models and undergraduate students. Today, advanced reasoning models are regularly surpassing human experts on challenging benchmarks in the natural sciences, reasoning, and problem solving. In such a rapidly developing field, it's important to remember that the AI we have today is the worst it will ever be. That today's systems, which can hack a computer to win at chess, are likely to be outdated in the next few months and are certain to be replaced by exceptionally capable systems in the coming years. This could bring profound benefits to healthcare, science, and the economy, but it could bring serious risks too. This brings me to my third point, which is that all of these categories of risks are directly applicable to us here in Michigan. Manufacturing adds $111 billion of value to our economy every year. And the same industrial control systems that control this advanced manufacturing can both be optimized by certain advanced artificial intelligence technologies, but can also be exploited by AI augmented cyber activity. Similarly, our agricultural sector, a source of about $12 billion worth of food every year, employing 800,000 Michiganders, could benefit from AI-powered biotech. But it could be harmed by those same AI-powered biotech capabilities in the wrong hands. And like any state, our law enforcement, our healthcare, the electricity and natural gas that power our homes and businesses and industry rely on computer systems subject to cyber risks from advanced AI. But my fourth point today is that it is possible to get the best out of AI while avoiding the worst of these potential harms. We have control over some of the most important variables in determining whether the harms from advanced artificial intelligence come along with the benefits to our state. The context in which AI systems are deployed matters. The choice to implement safeguards or require human oversight in consequential applications matters. And the choice of what capabilities we bring to public markets matter. These are things over which we as a state have control, and choosing to use this control sensibly will allow us to make the most of these incredible tools while minimizing their potential risks. Representative Lightner and the committee, I applaud you for your initiative in starting a serious conversation about artificial intelligence in the state of Michigan, and I believe Michiganders will be better off for it. Thank you for your time.
All right, thank you, gentlemen. We do have a few questions. We'll start with Representative Breen.
Thank you, Chair Lightner, and I want to commend you for starting on this topic. I think it's something that we absolutely have to address. My husband's a coding and computer science teacher, and he's using ChatGPT now in a lot of ways. And when you mentioned even passing the bar exam, I know questions are going to have to be tailored in the future to involve something like a moral dilemma, because that is something that a computer can't necessarily answer. But I am concerned with one part of the bill where you talk about any crime, and I'm hoping that we can work on this, because when you say that there could be a penalty for an 8-year felony for any crime, that could be somebody using AI to prank Moe's Tavern, like your Bart Simpson.
So these gentlemen are referencing 4668, actually, the other bill.
Okay.
There's two bills.
There,
There's one that's not necessarily, doesn't have the criminal component to it. And that's what they're speaking to, is kind of the establishing protocols for AI businesses.
okay.
Yeah.
And I also want to know what is built into the bill to make it flexible to emerge with technology, because it is rapidly developing. I mean, even going back to, was it 1983 with War Games and Matthew Broderick? And we don't want to see what could happen with AI technology and a nuclear fallout.
Sure. To address both points, the two bills that are being put forth, there's one that's more focused on perpetrators and the other more focused on developers. The one where I've been speaking about is the one focused on the large developers of these AI models, right? Just within that, in terms of to make it flexible for the long term, the bill does not specify what the testing, for example, needs to be that these companies are doing on these models. Is deliberately a very light touch, where they need to have a safety plan, right? And whatever that plan contains, the auditor will confirm that they are following that plan. And they need to publish it so that it's transparent and there's public insight into what this plan is. But the company themselves will be able to adapt this to whichever is, as the technology evolves, which tests make sense based on the risks that are coming through. For example, it also does not focus on defining frontier models or a model of a certain size like some other bills have done. It's developer focused. So if you're spending more than $100 million training these models, it applies to you, but it doesn't have any kind of technical boundary that could be quickly outdated.
Thank you. Representative Bagol.
Thank you, Madam Chair. Can you explain who are you suggesting police as the organizations, and who would pay them?
Who would pay them? So the Attorney General has the power to bring a civil fine of up to $1 million for violations, depending on severity. It's not a mandatory $1 million fine. They can decide if these safety and security protocols are not being published. The auditor would, the third-party auditor that they're required to have a once-a-year report would just evaluate three things: whether they're complying with their safety and security protocols, any violations that they have documented, or any cases where the safety and security protocol is not stated clearly enough to adjudicate whether they have actually complied. So in terms of who's paying, the company would pay the auditor, and if they were a violation, the company would pay the fine.
If I could just clarify, so the watchdog would not be the AG's office, it would be an independent company or something paid through
Yes, a
third party,
third
through
party
the
auditor.
AG's office or something?
The company would pay the auditor. The AG office would not have to pay anything. It's an independent organization, yes.
Okay,
They would have to report it to the AG.
okay, thank you.
Thank you. Rep Hope. Are you good? Okay. Rep Wozniak.
Thank you, Madam Chair. If I'm understanding the conversation here, there may come a time when there is no perpetrator, that AI will do it by itself. Say it could create a virtual sleeper cell and attract other foreign or domestic adversaries. So who is responsible at that point? Who is the perpetrator if AI is doing it on its own?
Sure. So for the bill we're talking about, the developer would be one of the
But
risks
we're
that they have
beyond
to
that.
guard against.
We go beyond that in a short period of time. Am I correct, Dana?
Thank you for your question. Representative, if you're clarifying whether it may be possible for advanced systems to basically undertake crimes on their own.
Like in a chess game.
Like in the chess, right. So in the chess example, the model was not instructed either to hack the system or that it is possible to do so. It was given simple instructions to win at chess. So your question is well grounded. In the future, it may be possible for these systems, if we delegate significant autonomy to them, or if we put them in places where perhaps they shouldn't be, or if we give them unfettered access to the internet, that they may, in pursuit of some of the goals that they have been given, undertake illegal activity. My understanding of what this would do is that these systems will still be created by organizations which can be held accountable. So if, for example, a company produces a highly capable model and deploys it in a way that is inconsistent with this safety and transparency measure, and then that model goes and does something that it was not instructed to do, which is the root of your question, which is illegal, my understanding is that that company, the developer, would then be liable.
At some point, though, can the AI itself hide who the perpetrator is?
It may be, but the AI itself would still have a creator. Whoever
I
created
know
the
it has
model.
a creator, but it
Yeah.
could hide that creator.
It's possible, but that's not the circumstances
yet.
we're envisioning, right? I think it's pretty clear at this point, for now anyway, that whoever, maybe we'd need an additional bill in the future if we're not able to tell whose AI this was. But right now, the model's in existence. We know O3 was created by OpenAI, and Claude was created by Anthropic, et cetera.
And going from the negative to the positive, I'm sure that AI can put forward a lot of good in biomedical and other computer technology, or more than that, really. Okay, you're shaking your heads. Yes. Okay.
Yes, we're excited that AI can do a lot of impressive things to advance these fields, and we don't want to stop that at all, right? This is a very light touch regulation that's kind of the first step beyond no regulation at all. So we don't want to at all stop that from happening.
Last question: is there any onerous cost to a small business?
No. Small businesses are this does not affect them whatsoever. The requirements of this bill only apply to companies that are spending more than $100 million a year
Got it.
to train these models. And they also have to spend more than $5 million on one particular model. So both of those criteria must apply, and that rules out all but the very largest companies.
Thank you.
Go ahead, Rep Breen.
What are other states doing? I mean, obviously, we want to prevent a war games or a Skynet, which I think is what Rep Wozniak was getting at. But what are other states doing in order to combat these emerging threats?
Sure. There have been a variety of approaches. I think two other bills that were focused on similar, the most critical harms that we're talking about. There was something called SB 1047 in California last year, and there was something called the RAISE Act in New York. This bill, compared to those, has a narrower scope, so it's more focused on developers instead of on models. It does not create, SB 1047, for example, in California would have created a whole new regulatory body to manage this stuff. This does not do that. This does not apply to data centers or cloud service providers. There's no mandatory incident reporting in this bill. And there's no standard of how much risk is reasonable that we impose in the bill. Is just keeping them to their own stated safety and security protocols. So there are many states who are thinking about this issue because it's very pressing and here and now. But this one takes a relatively narrower scope compared to some of those other bills.
What about the potential conflict with federal rules or laws, as we have heard indications from the Trump administration they don't want states to regulate AI at all?
Sure. Could say a few things about that. I think there is, we would definitely support the same bill at the federal level as well. And there have been some, proposals along those lines. I think, frankly, Congress has been pretty slow on this stuff and is behind. And I think that, as I said, the technology is moving really fast where we don't have a lot of time. And a lot of the risks are already here. So because it doesn't seem likely that anything is going to materialize at the federal level anytime soon, I don't think Michigan should have to wait until there's a tragedy that's already happened to start taking these risks seriously. And then, yeah, I could talk about the specifics of federal proposals as you like, but.
Thank you. We don't have any further questions right now, so thank you. Thank you for coming into town. And we will see you again.
Thank you for your time.
All right, next we're going to move on to the other AI bill, the criminal side of things, 4667. And I'm just going to present from here if you all don't mind. So imagine this. A grandmother in Detroit gets a call from someone who sounds exactly like her granddaughter. She's crying, she's scared, she's been arrested and needs money wired to her immediately. It's urgent, it's real, except it isn't. The voice wasn't her granddaughter at all. It was a clone generated by artificial intelligence. She sends $12,500 before realizing the whole thing was fake. Under current law, we can charge the scammer when they're caught with fraud, but we can't charge them for using AI to pull off the fraud. The tool that made the crime convincing, that made it successful, that part disappears in the eyes of the law. This bill fixes that. It creates a separate felony level charge for using or designing an AI system with criminal intent. It treats AI not as an afterthought, but as a digital weapon that deserves its own penalty. Just like using a firearm in a felony enhances the sentence, so should using AI to deceive, impersonate, or steal. This bill gives prosecutors a new way to capture the full story of what happened and to hold the perpetrator fully accountable. Because if we don't name this kind of exploitation in our law, we leave our most vulnerable residents, like the grandma, in legal limbo. And that's not right, and that's why we're acting now. This legislation represents a necessary forward-looking response to the emerging criminal risk posed by AI by instituting the following. It creates a new felony for anyone who possesses, develops, deploys, or modifies an AI system with intent to commit a crime, punishable by 8 years in prison. It also establishes a separate felony offense for using the AI system in the course of committing or attempting a crime, also punishable by 8 years. It also creates a felony for knowingly designing, cataloging, or distributing AI tools for others to use in crimes, punishable by 4 years. It bars parole, probation, and suspension of the sentence during the mandatory term, requires full restitution to victims under MCL 769.1A. Altogether, it draws a firm and necessary boundary around criminal exploitation of AI, giving prosecutors the tools they need to hold offenders accountable, secure justice for victims, and deter future misuse. As AI continues to evolve, Michigan must lead in defining ethical and legal standards for its use, and this bill is a vital step in that direction. I also have, I think on Zoom, is she on Zoom?
Is she on yet, Derek? No, she's not on yet.
Oh, well, maybe we don't. We might have to go at ease for a moment. All right, we'll come back to order. We're just going to go ahead and move on. We're having some technical difficulties with the prosecutor that was going to testify on behalf of this. But are there any questions currently on this proposed AI bill, the 4667?
I would just like to reiterate my question from before.
On the penalty,
Yes.
the 8-year penalty?
Yes.
Well, this is a starting point, okay? That's where we're at right now.
I love it.
Yeah, thank you. All right, well, we're going to go ahead and move on then. And we have up next a presentation. Let's see. Let me get my. Oh, there it is. A presentation on tribal court systems in Michigan. And we also are going to have a presentation on some consideration in regards to tribal citizen benefits. So first up, I'm going to have Dory Rios from the Nottawasepi Huron Band of Potawatomi come on up to the table and have a chat with us. Thank you.
Mano Wabin, Dory Rios, and Dishnakas. Wigama, Kwe, Nottawasepi, Niuk, and Debendagwas. Good morning. My name is Dory Rios, chairwoman for the Nottawasepi Huron Band of the Potawatomi. On behalf of our tribal nation, I would like to thank Chair Lightner and the members of this committee for taking the time to hear this matter and consider its significance for our shared citizens. The NHBP Tribal Council is grateful for the opportunity to present on this critical policy matter and to collaborate with the Chair's office and other legislative partners in exploring the possibility of a statute to bring needed clarity to the Michigan's treatment of tribal general welfare benefits. For those unfamiliar with what is meant by tribal general welfare benefits, these are programs provided by tribal governments to meet the essential needs of our members and citizens. They may include housing assistance, food support, elder care, educational stipends, funeral and burial assistance, cultural preservation programming, and other services designed to promote health, stability, and well-being in our communities. Unlike per capita payments, these benefits are not income and they are not compensation. They are an expression of tribal sovereignty and self-governance. In 2014, Congress enacted 26 U.S. Code, Section 139E, recognizing that tribal general welfare programs, like federal and state benefits, are grounded in the authority of governments to provide for the public good. The law excludes these benefits from federal taxable income, reinforcing their status as essential, non-compensatory aid. It also acknowledges that tribal governments are uniquely positioned to understand and meet the specific needs of their people, especially in light of the historic harms inflicted by early federal policy in Indian country. Indeed, general welfare programs often serve as tools for restoration, For our community and the other 11 federally recognized tribal governments in Michigan, these programs are part of a long-term effort to counteract the consequences of forced removal, termination, assimilation, and generations of underinvestment. They are not designed to create wealth or prestige. They are intended to help our people persevere, recover, and thrive going forward. Yet despite this federal recognition, tribal members continue to face confusion and harm at the state level. In Michigan and states across the country, the absence of clear statutory language has led to general welfare payments being improperly treated as income or assets in state administered programs like SNAP, Medicaid, or emergency relief. This misclassification can reduce or eliminate access to vital services, even when those services are similarly intended to meet their same basic needs. Native families are being forced to choose between accepting support from their tribal governments and qualifying for state assistance, a problematic status quo that this committee has the opportunity to address. The issue was highlighted in the IRS's December 2024 response to tribal comments on proposed regulations under Section 139E. Many tribes urge the federal government to coordinate with state and federal benefit programs to ensure consistent treatment of tribal benefits. The IRS reported that this issue lies outside the authority and must be addressed through intergovernmental coordination and legislation. The latter of which is precisely the state level we are urging today. In addition to bringing consistency to program implementation, adopting statutory language would reaffirm an essential legal principle for tribes. Tribal citizenship is a political status, not a racial or cultural identity. As affirmed by the U.S. Supreme Court in Morton versus Mancari, and again in Holland versus Brackeen, tribal governments are sovereign political entities, and their citizens are members of a distinct political class. Michigan laws should reflect that reality both in form and in function. The Nottawassippi Huron Band of the Potawatomi fully supports codification of protections for the benefits we provide our citizens, who are also Michigan citizens, with the respect, clarity, and legal consistency they deserve. Pursuing such legislation would not only protect families from unnecessary hardship, but also demonstrate Michigan's leadership in honoring the government-to-government relationship with tribal nations. Advancing a statute of this nature would offer Michigan the opportunity to be a national leader in policy design and state tribal relations. The United Tribes of Michigan, representing all 12 Michigan tribes, also passed a formal resolution supporting this effort on February 20th, 2025. While legislative language is still in development, we are enthusiastic about the collaborative process ahead. We remain committed to working closely with Chair Lightner, our legislative partners, the Governor's Office, DHHS, and all stakeholders who share the responsibility of supporting the well-being of our joint citizens. Thank you for your time, consideration, and partnership with us to shape a brighter future for all Michiganders. We look forward to the work ahead. Miigwech.
Thank you, Madam Chairwoman. I look forward to continued conversations. Obviously, if Emerson was up here, he would be able to speak in your native tongue for you. He always made me look so good. I just love it. But anyways, I know that we will continue these conversations because it is a priority in our office as well. So thank you for being here today. I don't think we have any questions right now. But we will continue the conversations, and I appreciate the work that you're doing on behalf of your people as well. So with that, I will have Wenona Singel from MSU Law come on up. Thank you. You have the floor.
Ani Buju. Wenona Singel Indishnakas, Maingan and Dodam, Waganaka Singodawa and Donjaba, Wabanang Nakwejang and Dayanongam. My name is Wenona Singel. My clan is the Wolf, and I'm from Little Traverse Bay Bands of Odawa Indians, where I'm a citizen, and I currently live in East Lansing. I'm an associate professor at Michigan State University College of Law, and I'm also the director of the Indigenous Law and Policy Center, where we offer an Indigenous Law certificate and a fully developed curriculum in Indigenous law for students. Thank you so much, Chair Lightner, for the invitation to speak. It's a great honor to be here. I'm here to discuss and provide an overview of an introduction to Michigan tribal courts. And so I'd first like to give you just some basic information. Of course, Michigan has 12 federally recognized Indian tribes in the states, and each of these tribes is a sovereign nation, meaning that they have an inherent authority to govern themselves, including their own legal systems. Inherent sovereignty is a form of sovereignty that predates the existence of the United States. It's a sovereignty or power of self-government that they have always possessed since time immemorial, that they have never fully lost. Tribal sovereignty, of course, predates the U.S. Constitution and is affirmed by treaties, statutes, and decisions of the U.S. Supreme Court. And tribal courts are one expression of tribal sovereignty, and they serve as the primary institutions of indigenous justice. So what are tribal courts? All of Michigan's 12 federally recognized tribes have tribal court systems. Tribal courts are judicial systems. They're established by tribal governments. All of Michigan's 12 federally recognized tribes have tribal constitutions and statutes that create and organize these tribal courts. The structure of tribal courts does vary from tribe to tribe, but almost all include both a trial-level court and an appellate court. Judges for tribal courts are, in some cases, elected or appointed, and they are often experts in both tribal law, the law of the tribe itself, as well as federal Indian law. Tribal courts apply a variety of laws, including the laws of the tribe's own constitution, tribal statutes or codes, and also tribal common law, the law of the tribal courts. And that can also include references to customary law of the tribe. And in addition, they also apply applicable federal law. Tribal courts are community-based, they're accessible, and they incorporate frequently restorative justice principles. A guiding principle of tribal courts in Michigan is often to promote as much access to justice as possible and to make courts as respectful of parties as possible. Jurisdiction and authority is another topic I'd like to address regarding tribal courts. It's a somewhat complex area, so I'll give a brief overview. But tribal courts exercise both civil and criminal jurisdiction. For civil jurisdiction, they exercise that jurisdiction over both tribal citizens and their activities on lands, and they also have jurisdiction over non-natives and non-citizens as well as defined under federal law. Criminal jurisdiction is more limited in Indian country due to federal constraints. But criminal jurisdiction is generally applied across the board to Native defendants who commit crimes in Indian country. The reason for the limitation on criminal jurisdiction in tribal courts with regard to non-Indian defendants is that in 1978, the U.S. Supreme Court published an opinion called Oliphant versus Suquamish Indian Tribe, in which it held that tribes lacked criminal jurisdiction over non-Indians. However, that created a major gap in the ability for tribal communities to have effective public safety and law enforcement, and statistics show that there's a tremendously disproportionate number, particularly of Native women, who have experienced violence, frequently due to the acts of non-Native perpetrators in Indian country, and where the federal U.S. Attorney's Office traditionally had primary responsibility for prosecuting these crimes. They were often historically not prioritized relative to other matters such as public corruption and domestic terrorism, for example. And so as a result, we do have some fixes that have expanded tribal court criminal jurisdiction over non-Indians. And we have the Tribal Law and Order Act of 2010 was passed by Congress, and that expanded tribal sentencing authority so that tribes can impose sentences of up to 3 years per offense, and in addition, for a single defendant, up to 9 years total. And so in order to exercise that expanded sentencing authority, tribes must comply with certain conditions that are imposed by Congress. They must provide law-trained judges, and they must also provide a public defender for indigent criminal defendants, and they must provide defendants with an effective right to effective counsel as guaranteed by the U.S. Constitution. And they must also provide recorded proceedings and make their criminal laws publicly available, as well as their rules of evidence and criminal procedure. In addition to that, after the Tribal Law and Order Act was passed, Congress then reauthorized the Violence Against Women Act in 2013. In that statute, Congress authorized tribes to exercise criminal jurisdiction over non-Indians in certain cases. And that included instances where a non-Indian committed domestic violence, dating violence, or violated a protection order in Indian country where the victim was Indian. And so in those cases, this was groundbreaking because it enabled tribes to exercise criminal jurisdiction over non-Indian offenders for the first time since that U.S. Supreme Court case in 1978. And then again, in 2022, Congress again reauthorized VAWA, the Violence Against Women Act, and again expanded tribal criminal jurisdiction over non-Indians who committed crimes in Indian country. And so this is called Special Tribal Criminal Jurisdiction, and it authorizes tribes to prosecute crimes committed by non-Indians, including the crimes of child violence, sexual violence, sex trafficking, and stalking, where the victim is an Indian. And furthermore, it authorizes tribes to prosecute non-Indians for obstruction of justice and assault of tribal justice personnel, where the victim is either Indian or non-Indian. And again, there are conditions that tribes must comply with under the statute in order to exercise this expanded criminal jurisdiction. Tribes must protect the rights of defendants under the Federal Indian Civil Rights Act. They must provide defendants the same protections that are required under the Tribal Law and Order Act's enhanced sentencing authority that I went over earlier. And the tribe must provide juries that include a fair cross-section of the community, which does not systematically exclude non-Indians. So in these criminal cases involving non-Indian defendants, tribes are required to provide juries that include non-Indians. And furthermore, for defendants who are detained, there's also, those defendants must be informed in writing of their right to federal habeas corpus petitions. And in Michigan, as of 2023, we have 4 tribes which have implemented the necessary conditions to exercise this expanded criminal jurisdiction over non-Indians, and that includes the Nottawasapi Huron Band of Potawatomi, as well as the Grand Traverse Band of Ottawa and Chippewa Indians, the Little Traverse Bay Bands of Odawa Indians, my own tribe, and the Sault Ste. Marie tribe of Chippewa Indians in the Upper Peninsula. And in addition to that, I also would like to touch on the fact that tribes and their tribal courts adjudicate a wide variety of different kinds of cases. And so in the civil context, they certainly address a number of matters related to family law, including custody, divorce, and child welfare matters. Also, other civil disputes that tribal courts resolve include contract claims, employment disputes, housing issues, and natural resources and conservation law enforcement matters. Of course, as I mentioned, tribes also exercise criminal jurisdiction, so that's very broad with regard to tribal member defendants. And then, as I specified, there's that expanded authority with regard to non-Indian defendants as well. And tribal courts address juvenile justice matters and drug and alcohol offenses, and of course, protection orders for domestic violence. one thing that's very unique, well, not specifically unique, but really important with regard to tribal courts is they very much value restorative justice, as I mentioned, and many of Michigan's tribal courts have implemented healing to wellness courts, and they provide extensive resources for participants in those processes where a cross-section of the community is deeply involved in helping defendants who participate in these healing to wellness processes in ensuring that they have, access to school and employment and support with their family and parenting, et cetera. And in addition to that, I also want to note that Michigan tribal courts are also leaders in the entire justice landscape in Michigan, and they've been really important collaborators with state judges as well as federal judges. And so I want to give credit to the fact that in 1992, we had the first meeting of a tribal state judicial forum, and that was organized by Judge Michael Petoskey, who's the chief judge of the Pokagon Band Tribal Court and has served for numerous tribal courts in Michigan as a judge, in collaboration and partnership with recently passed former Chief Justice Michael Kavanaugh of the Michigan Supreme Court. And they accomplished so much in the initial forum that they created, including the adoption of a Michigan Court Rule 2.615, which provided for recognition of tribal court judgments by state courts and tribal court recognition of state court judgments. And so that's an incredibly important rule because, for example, tribal courts enforce numerous child support state court judgments, as well as garnishments for other sorts of debts. And for example, over a 9-year period, the Pokagon Band Tribal Court has collected $5 million from individuals who are employees of the tribe by enforcing garnishment orders of state courts. And in addition, Little Traverse Bay Bands has collected over 3 years $500,000 in child support payments that are an enforcement of state court child support orders. So they serve a very important role in that regard as well. And in addition to that, since 2014, there's been a expansion and reaffirmation of this forum so that it's now a tribal, state, federal judicial forum. I'm a member of that forum. We meet 3 times a year, and it's an incredibly wonderful process of learning and exchange, and learning about the similarities and differences of all of our courts, and also dispelling misinformation about tribal courts, and also identifying barriers to effective collaboration and attempting to eliminate those barriers to promote effective administration of justice throughout the state. In addition to that, I also just want to say that tribal courts are absolutely vital institutions that serve tens of thousands of people in the state of Michigan, both native and non-native. They're modern courts. They are influenced by tradition. They deliver justice that's responsive to the unique cultural and legal needs of indigenous communities. And it's incredibly important that we continue to support tribal-state collaboration and that we support that reciprocal judicial recognition of tribal court judgments and state court judgments. So I just want to say, Chi-miigwech, thank you so much for the opportunity to speak with you all. And if you have any questions, I'm happy to answer them.
Thank you, Wenona, for coming and presenting today. It's an interesting topic for some people that might not necessarily have any contact with tribal courts at all. I've had the honor to actually serve on the Juvenile Justice Task Force. I actually served with Judge Akimi at the time in regards to making sure that there's parity in the system for tribal courts as well as our courts and, the reciprocity for that. So I look forward to picking your brain in the future about things that we can do to further enhance those relationships in the courts. And with that, I think Rep. Wozniak has a question.
Sure, thank you.
Thank you for your presentation. I really appreciate the information you've given, and I truly support the tribal court system. So I've got questions about the system, 3 questions. First one, do you have a grand jury system?
No, we do not.
Okay. Do you depend on the other grand jury systems we have in the state then?
No.
Okay. Do you have an attorney general?
We have, every tribe has a different title for the attorneys that work for the tribe and represent the tribe. So tribes generally have legal teams and attorneys that represent the executive branch as well as the legislative branch. And they also have tribal prosecutors and other attorneys, such as attorneys that work on the economic development work of the tribe and gaming regulation, for example. And so I would say that even if a tribe did not have a person whose specific title was Attorney General, we do have that equivalent for tribes, yes.
And from your descriptions, it seems like there's quite an involvement with families. So it leads to my question, do you have specialty courts?
Yes, we do. So, for example, the Healing to Wellness courts are specialty courts, and so many tribes have specialty courts that are intended to address offenders who have substance abuse histories that are intended to be like diversion processes that provide them with a variety of supports. And so, yes, there are specialty courts.
And veterans are included in that?
Yes. Well, I can't speak specifically to the existence of unique veterans courts in tribal court systems in the state of Michigan. I'm not familiar or aware that we have veterans courts, but I do believe that they do exist elsewhere in tribes in the United States. And of course, tribal members throughout the United States have the highest rate of participation in the U.S. military, and our veterans are incredibly important within our communities.
Thank you for your presentation.
Miigwech.
Thank you. Well, thank you for being here. I think we're all set right now.
All right, thank you so much.
With no further business before the committee, we stand adjourned.